May it please the court.
Sure.
Anthony Brown for the defendants and appellants Christopher Keeling, Stephen Gross, and Gregory Maxwell. Your Honors, if I may, I'd like to jump to the issue of prosecutorial, the Smitty presumption of prosecutorial independence, because I think it's potentially the most consequential issue for this appeal. As we've argued in a case like this one, where the plaintiffs are alleging wrongful prosecution, there's an evidentiary presumption that the prosecutor who charged the case exercised his, in this case, independent prosecutorial discretion to bring the charges.
There is, but it is a rebuttable presumption, and the district court was aware of it, and she was aware that it doesn't hold where there's a showing of fabrication.
Well, it holds when the plaintiffs are able to present substantial evidence that fabrication of evidence overcame or somehow vitiated the independence.
What you're talking about right now is the language of sufficiency of evidence and weighing of evidence, and we're on interlocutory appeal. So it's very distracting in the briefing to talk about sufficiency of the evidence given our limits here.
I'm not talking about the sufficiency of the evidence. I'm doing what the court allows on a qualified immunity appeal. I'm accepting all of the facts that the district court found is true. I'm arguing based on the undisputed facts in the record that the plaintiffs failed to overcome the Smitty presumption. And the reason, in this case, it's a unique situation, and it's not one that's been seen in other cases before. The first allegation is that two of the deputies, Keeling and Maxwell, included statements in their police reports that witnesses had seen the plaintiffs or had seen shooters. Those two witnesses came to the preliminary hearing and testified. And they testified that they didn't make those statements. So the reason that the Smitty presumption doesn't apply here is that for a fabricated police report to undermine the prosecutorial independence, the prosecutor has to rely only on that police report. When the prosecutor hears the very witnesses testify that they deny making those statements, then the prosecutor has the ability to make an independent
judgment. The first
judgment.
problem we've got is what you just said isn't really accurate as to both of the witnesses. It is different. What we don't have right at the top of the decision tree, we don't have a defendant by defendant, claim by claim analysis here. It's one of the arguments that you made in your briefing, and it makes it this makes this a very, very trying record to parse, particularly because we have briefs without record sites. But it is not accurate. You said that. In your briefing, you said that both of them recanted.
That's correct, Your Honor.
What is the support for that they both recanted?
Well,
Sheila and Denisha. We're talking about Sheila and Denisha.
No, we're talking about Jasmine Thompson and Shadonna Williams. So the allegation...
In the report says that those two people specifically told the deputies that they had seen the shooting.
So Detective Maxwell's report states that Jasmine Thompson saw Fat Man and two other people shooting. It states that Shadonna Williams told him that she saw three shooters but couldn't identify them.
And that's reported differently by Keeling. So hence my concern that we have to talk about which defendant we're talking about.
That's correct.
And which plaintiff, by the way, because it's going to change when we talk about different plaintiffs as well.
I agree. Then Detective Keeling separately interviewed Jasmine Thompson by phone. She told him that she had seen the plaintiffs and also Fat Man. That's Jasmine Thompson. Shadonna Williams wasn't interviewed after this. When they came to the preliminary hearing, Shadonna Williams said, I didn't see anybody. Jasmine Thompson said, I didn't see anybody, and I didn't tell that to the detectives. Okay? Neither of the detectives testified, and so the prosecutor was left with exactly the same evidence that the plaintiffs are presenting now to claim that there was fabricated evidence. And based on the fact that the witnesses came forward and the detectives didn't testify, the prosecutor was exercising his independent judgment to say, I have two other witnesses here who have been consistent, Sheila Lair and Denisha Williams. They both identified the plaintiffs as shooters. Denisha Williams knew Plaintiff Glass. He had been over to their house 100 times. Sheila Lair knew them as well. And therefore, I'm going to move forward on the charges.
There are other allegations, as you know, about fabrication of evidence that relate to other witnesses, counsel.
I'm not sure which ones you're talking about, Your Honor.
Well, I don't mean to be rude, but it's not really the day for you to ask questions of the court.
No.
What we're looking for is your strongest argument, and I think you've given us your strongest argument. So I don't want to take up the rest of your time.
Well, the problem with this case is that the district court doesn't quite say exactly what its ruling is based on. So I'm trying to address what the district court said.
I totally agree with you,
Okay.
counsel. I'm not trying to ruin your day or give you a hard time, but one of the very challenging aspects of this case is that we don't have defendant by defendant allegations.
I agree.
And
Your
we're on
Honor.
interlocutory review.
And so the way we try to approach this as best as possible is to say, what were the undisputed facts? What did the district court herself find? Because I think we're stuck with those findings to the extent that they are there. And based on those things, as a matter of law,
Well, actually, I have a lot of sympathy with the district court after wrestling with this record for some time, and I think there's room all the way around. In hindsight's 2020. I'm not here to beat up on anybody, but so your allegation talks about witnesses recanting, and until this moment, I didn't know which two witnesses you were talking about.
Okay,
I would have thought we were talking about the two eyewitnesses, Sheila and Donisha.
They never recanted.
Exactly.
They testified at trial, and they
exactly.
The witnesses. I'm sorry if it wasn't clear in the briefing, Your Honor. The two witnesses that are the key witnesses for this determination, the only witnesses that the plaintiffs say are Jasmine Thompson and Shadonna Williams.
Hence my concern and I guess curiosity about why we're talking about two other witnesses and your statement that they recanted.
I don't believe we stated that those two witnesses recanted, Your Honor. And if we did, then I was mistaken.
All right.
Okay. Sheila Lair and Donisha Williams were consistent. They testified. They both told the detectives early on that they saw the plaintiffs, and then they testified at trial that they saw the plaintiffs.
Well, who testified at the preliminary hearing that Rayford shot other than shooting into the air?
That was Donisha Williams.
I don't think so. Can you give me the record site for that?
Yes. Well, I can tell you that the district court
maybe when
made
you
that
come
finding.
back. I don't want to take your time on it.
Okay, I'll do it when I come back.
My read of the record, so I'm not trying to be mysterious. My read of the record is that the prosecutor argued that they didn't know if Rayford had shot towards a person or towards the house, and that the finding by the presiding judge was very clear that he was relying on the gang allegation, and to say that there's probable cause that he acted as an aider and abettor.
That's not correct, Your
Well,
Honor.
then maybe when you come back, if you could give me a record site to tell me how I'm misreading that, but I really welcome it.
I will.
Let me change that. Let me change the argument.
If I'm just going to finish this in fairness, because this is very important to both parties, and I don't want to. I am looking at the prosecutor arguing this is now at the jury. We don't know if Rayford fired into the air or at the house, but he should be found guilty either as a direct participant or as an aider or abettor. At the preliminary hearing, the court ruled there was sufficient evidence to conclude that the crime occurred by the defendant Dupree Glass, for which the defendant Juan Rayford is responsible as a result of gang allegations. And just so you have this, it's 3 ER 13738. I want to give you a fair opportunity to respond, so to just put a pin on that. Judge Smith, go right ahead.
Are you ready?
I am, Your Honor.
I want to turn to the malicious prosecution.
Yes, sir.
So the malicious prosecution claim is brought separately under both the Fourth Amendment and the 14th Amendment, right?
That's correct.
What impact does the presence of independent probable cause have on each of these claims?
So under the malicious prosecution claim, an element is the absence of probable cause.
Right.
And so
under the Fourth Amendment, if you've got some probable cause established at the hearing, I would kind of take that away, right?
That's correct, Your Honor.
But what about the 14th Amendment?
Well, there is no malicious prosecution claim under the 14th Amendment. The Supreme Court's been pretty clear that it should be brought under the Fourth Amendment.
Well, a claim was brought under the 14th Amendment.
It was.
And you're just saying they can't bring such a claim?
That's correct, Your Honor.
I didn't see that in your briefing.
It wasn't raised by the plaintiffs in the case, and we didn't argue that below. We had assumed that it was under the Fourth Amendment. no one argued that our position was absent of probable cause would vitiate the entire claim. That was not disputed below.
What about the problem of it's like nesting dolls, right? Because we have a fabrication allegation under the 4th and 14th, and we have then I don't know how to pronounce this one, and I'm not from Idaho, WIG case. I don't know.
I don't know how to pronounce that.
We'll go with what?
WIG. Okay.
Okay.
Yeah.
And so, but you appreciate the problem, right? If we have a fabrication claim, if we establish fabrication, then that falls away, and they can absolutely relitigate proximate cause if there's a fabrication. Another problem I'm going to talk to opposing counsel about is that there are allegations here and there that Denisha recanted, or that she wanted to recant, and that there was a pressure placed upon her to not recant. I don't see any support for that anywhere in the record. So for both of you, just so you know, I have set that aside because I don't think it's supported in the briefing that we have, and because I suspect that's why the district court made not one mention of it in her order as well. So I think we're looking at the reports that these folks authored, and then there's allegations about testimony as well.
That's correct. Denisha Williams was not.
Oh, go ahead.
Yeah, she wasn't deposed below. She didn't submit a declaration.
Right.
The allegations, the facts that Your Honor was talking about are supported by references to the complaint.
Exactly.
That's it. So
Yes.
there's no evidence of it.
Exactly. And but to circle back to Judge Smith's point, because this case has a lot of tangents, right? That's the problem for the malicious prosecution claim. We've got this allegation of fabrication, and until that is resolved, I don't think you can rely on the defenses you're relying upon.
No, that's not true, Your Honor.
Why?
This is summary judgment. You can make all the allegations you want, but it's summary judgment. If I claim you have no evidence,
Interlocutory appeal.
But you still have to come forward with some evidence. And if
Yes,
there's
and
no
we have
evidence,
jurisdiction under Anderson versus Marsh if there's no evidence. So and I was waiting for you to say that. So thank you. So now could you circle back to Judge Smith's question? How does that help you
I want to make my position clear that there is no evidence in the record to support the allegations that you mentioned.
What allegations are you talking about now?
About the Denisha Williams wanting to change her story.
I just said that.
Okay, then we agree. I just wanted to make that clear. Okay.
You probably want to take yes for an answer on that one. But please, if you could circle back to Judge Smith's question.
I will.
Well, I think he answered my question. I don't think he's got to answer it again. All I'm trying to do is get the points in the middle of this that were of concern to me. It seems to me that the district court didn't sufficiently separate the defendants when analyzing any of these claims. So do I just send it back?
I don't think so.
I mean, the problem comes that if I'm going to take that approach on any of these claims, I guess I'm trying to figure out which ones do I separate and which ones I don't. Because what the district court did is they laid out a big fact scenario. Then after laying out a big fact scenario, which I think was mainly premised on the fabrication claims, I don't think that really said much about the other claims, but really on the fabrication claims. Then they went into doing the analysis, and they lumped them all together, and we didn't know what they were saying. So my worry is, do I send it all back to have her do it again?
I believe that the court can rule on the Brady issue right now.
The Brady issue.
Well, it's going to be ruled on right now.
And the ruling would be to grant summary judgment.
I understand the Brady issue.
What else?
I also believe that the fabrication of gang evidence for Gregory Maxwell can be ruled on right now.
Now, if you're going to go the fabrication for Maxwell, I can understand where you're getting there, but for the FI cards, they were well before he was there, and so I don't think that's so big. But let's look at his investigative reports.
So Gregory Maxwell was the officer who showed up the night of the shooting.
I know.
But he didn't have anything to do with the FI cards.
Well,
I understand that. We got by that. Okay. Let's go to the fabricated investigative reports.
Correct.
What about Sheila Lair's statement?
I don't understand. So here,
talking about Maxwell.
Right. So there is no allegation that Sheila Lair's statement was fabricated, and there can't be, because in Gregory Maxwell's report, she said she saw the plaintiffs. At the trial, she said she saw the plaintiffs shoot. There can't be a fabrication. And the plaintiffs didn't raise it as a fabrication below. That was another instance of the district court finding a claim for the plaintiffs.
Counsel, you were going to tell us about the claims you think we can dismiss now.
I think the Smitty...
And one of them was Brady, and the other was Maxwell. What's your, just quickly, because you're out of time.
else?
What is your strongest
the prosecutorial presumption claim? That's right. And that's based entirely on undisputed evidence.
Defense, that's not a claim.
And
what claims do you want us to reverse on?
So
Brady?
On all of the allegations that the plaintiffs fabricated gang evidence, that's a separate kind of fabrication. I think we're entitled to summary judgment. On Brady, we're entitled to summary judgment. On the failure to intervene, we're entitled to summary judgment, especially because of the cases we cited about why it wasn't clearly established at the time. I also believe that in light of all those facts and the undisputed facts, that we're entitled to summary judgment on the malicious prosecution and also the conspiracy claims.
Okay, so you're out of time, you're over time. But we'll put 2 more minutes on the clock when you come back.
Thank you, Your Honor.
Thank you for your argument.
There's a button right underneath the lip if you want to lower the...
Thank you.
Entirely up to you.
Thank you, Your Honor.
Go right
May
ahead.
it please the court, Annie Deladonna, on behalf of the plaintiff appellees, Juan Marshall Rayford and Dupree Antoine Glass. I want to address, before we get started, a few issues that my colleague just raised with regard to Maxwell and ruling on the Brady issue. I want to make sure that the court understands that Maxwell, his involvement in this investigation might have ended the night of the shooting. However, as counsel has pointed out in the new tape that they provided to the court and the transcript they provided to the court, Deputy Maxwell was actually present during that interview. So his involvement continued.
Present
during that taped interview of Juan Marshall Rayford. And that's clear at the very first couple sentences of that transcript. He did not leave. He talked to Gross. He talked to Keeling. He was involved in this case. But more importantly, he wrote specifically on the charge line, along with attempted murder and shooting at a dwelling, he wrote a gang designation, which referred this entire case to the gang detective, Keeling.
I have a number of questions that there's probably about a half a dozen of them, but I think I can do this quickly, and I just want to make sure we haven't overlooked anything. They're very distracting allegations and concerning, and we need to know if there's support for them. There's an allegation that during the appellate investigation, both Sheila and Denisha admitted to investigators that they lied at trial. That's the complaint at 118. Is there any support for that?
Yes, there is. And it's Dan Mulrennan's declaration, which I believe is in the docket. Dan Mulrennan's declaration, which should be in the docket.
I've read that declaration.
Pardon?
I've read the declaration.
Okay.
And it says that Denisha didn't want to talk to him.
Right, but there's another declaration where he indicated that Denisha told him, I wouldn't have testified against them if they had just told me who the real shooters were.
That's not the same as saying that she lied at trial. That's the support?
That's the support, Your Honor.
Am I right that there's no NAPU claim here?
I do not believe so, Your Honor.
All right. Is there any support for the allegation that is at 126 of the complaint, paragraph 126, that Keeling visited Denisha and told her that if she went forward with the truth, the DA would properly press charges for perjury?
That comes from Denisha, Your Honor.
Well, we don't have any declaration from Denisha. We've got nothing from Denisha.
Correct,
is that right?
Correct, Your Honor.
So is it from your investigator?
It's from our investigator, correct.
Anywhere else?
No.
Okay. I have one more that I want to make sure. It's paragraph 128. Fearful of facing legal consequences for a mistake she made at 15, she stopped returning your telephone calls.
Correct, Your Honor.
But you're not planning to be a witness in this case. But
I actually was a witness in the underlying innocence trial because Denisha said to me on the phone, again, I would not have testified against them if they had just told me who the real shooters were.
Okay, so the district court made no mention of these allegations about any witnesses lying, officers knowing they lied, officers trying to prevent or coerce people from coming forward and prevent them from recanting. And I am understanding that's because the district court knew she didn't have any admissible evidence on those allegations. Are we missing anything?
No, Your Honor, but I think we're guessing as to what the district court did.
Well,
Because she also didn't mention Jones, and my colleague points out, well, that means she thought it was immaterial. She also didn't mention the tape, and my colleague points out that that's reversible error. So we're reading into what the district court did or did not do and what she felt was important. It's a 20-page order based upon, I'm sorry.
please, I didn't mean to interrupt you. Go
I
ahead.
was going to say, based upon a 22-year-old case, this would be a 500-page order if we expected her to address every single underlying
But we
fact.
can only go from that. We're reviewing her order, and we're trying to figure out what we had here. And I think she correctly understood she didn't have any, from what you just told me, she correctly understood she didn't have admissible evidence. So for purposes of trying to make sure we're communicating clearly, I have sort of scraped that off the top. I don't think this is a WIG claim. We don't have that here, counsel. So that becomes really important if we're talking about whether or not there's a fabrication, a colorable fabrication claim for purposes of relitigating the probable cause finding.
Right, but if we get to the probable cause, I got to take all the suppressed evidence out.
I'm not there yet.
Okay.
So what she did do, very clearly, the district court said that the reasonable jurors could decide that these witnesses lied. But I don't see anywhere any analysis of proximate cause.
Causation is addressed. She addresses Spencer versus Peters. In fact, counsel says she doesn't address causation, but if you look 2 lines above in her order, she specifically addresses Spencer versus Peters.
She cites it.
Yes, and she addresses that. And remember, causation
and
is an issue
we
for the
need
jury.
defendant by defendant because the facts are quite different for each defendant, and we don't have that, counsel.
And I agree with Your Honor.
All right.
That it's a little
So opposing
convoluted.
counsel started by saying, right now, even though we're in interlocutory review, we could and he wants us to reverse on the Brady claim.
Yes.
To save time, I'll tell you, I think he's right. So could you tell me what you think I'm overlooking? I saw a lot of allegations about failing to collect evidence, failing to interview witnesses. I didn't see allegations about
Withholding exculpatory or
suppressing.
mitigating evidence.
Where is that?
Well, the biggest one, Your Honor, is Felicia Jones. Felicia Jones walks into the police
How
department.
is she exculpatory? I'm really familiar with the record. I know we all are. We take this very seriously, but why is it exculpatory?
Because she said 2 very important things to the police the day after the shooting. She said, number 1, my brother is a suspect. They're accusing him of being the shooter.
Say my brother is a suspect. She said she got the phone call.
And they were accusing her brother of being a shooter.
And
her brother was the shooter. So that's number 1. Number 2, she said the other most important thing is that Donisha and her family are lying because they said one thing to her on the phone. She gets to their house and they change their story. Now, Felicia Jones is a 6'4" woman. She's very imposing. This family completely changed their story. And now they're saying, oh, it was just Juan and Dupree who were shooting. That is exculpatory evidence. That is evidence that disappeared.
It's also not what the district court relied upon. The district court said that there's a Brady claim here because the defendants didn't disclose that they had fabricated evidence.
Correct. And
is that the theory that you're pressing today?
Yes, Your Honor. They had exculpatory evidence. They had evidence that they had changed these witness statements, that these witness statements had never said this. They put them in writing. They handed them to the DA as if it was the truth. That is suppression, and that is fabrication hand in hand. And I don't think that this judge came up with an entirely new, novel theory. This is not anything like the other cases. This is exactly what you find in these cases.
Why do we have briefs from the plaintiffs here that don't have record sites? In a case of this magnitude, how is that possible?
I apologize, Your Honor. It's a very large record.
If I can interject
Yes.
a question correct me if I'm wrong, but at the actual innocence proceedings, it turned out that there was forensic evidence to determine that there were only 2 shooters.
Correct.
Is that?
Yes.
Who did that?
The DA. And the DA's investigator who worked for the Sheriff's Department, Ed Anderson. He indicated that there were only 2 directions of fire, which is why it was so important that the police officers not disclose Bland, not bring Bland to court. He sat in their jail cell. He was arrested a month after the shooting. And again,
What was he arrested for?
He was arrested for having a concealed weapon. Again, they never tested that gun with the bullets they collected from the scene.
But your briefing, it didn't explain to us. It made it very clear that you were very concerned that he'd been arrested and hadn't been questioned about this case. He wasn't arrested for this case. And I'm not sure what it is you think that the police missed by failing to line him up with this case and question him about this case.
They said they were looking for Fat Man. They had access to the Cal Gangs database that would have given them the real name of Fat Man, which was Douglas Bland. They had him with a loaded gun. They had 6 bullets in their evidence room. They never compared them.
For Fat Man.
Pardon?
When did they say they were looking for Fat Man?
If you listen to the tape.
What tape, counsel?
The tape that counsel brought to you, the interview with Juan and Juan Rayford.
The post arrest recording.
Detective Keeling says, we're looking for, I'd like to talk to Brandon, and we're looking for Fat Man.
Okay, so getting back to Judge Hawkins' question.
I apologize.
Yes, I'm sorry. Let me go back to that. At the actual innocence proceeding, that there was forensic evidence that there could have only been 2 shooters.
Correct.
And by that time, this Brandon had said he was one of the shooters?
No, Brandon never came forward. Brandon was not interviewed. He never came forward, even though the detectives knew about him. He was given, they had his address. They drove by his house. They never interviewed him. And why? Because Brandon's father was a cop.
Well, but you fashioned this as a Brady claim. That's the failure to interview someone.
Yes.
It's not suppression of evidence.
Was Brandon ever prosecuted?
No, unfortunately, Brandon killed someone while he
Yes
was
or no?
Oh, no.
Not, it was a good decision to prosecute him, a bad decision not to.
No.
Okay?
No.
So by the time of the actual innocence proceeding, we know a couple of things for certain.
Right.
There were only 2 shooters.
Correct.
Okay? One of them may well have been Brandon, and the other one very probably was Fat Man, who by now was dead
Right.
from involvement in another shooting.
Correct.
What year was the actual innocence hearing?
2023.
Right.
It took us 6 months.
If I could,
Yes.
I'm going to change it just a little bit. So we go to the fabrication of evidence claims. First of all, I agree with my colleagues. I don't think the district court did a very good job of separating out all this stuff. So I could send it back for that, but I'm trying to help otherwise. So let's go to gross. What is the evidence that you rely on to stake your fabrication claim against Gross?
So Gross,
Besides the cards.
Besides the cards. Well, Gross testified at his innocence deposition that the only evidence he had that they were in a gang was his cards. He had no other evidence.
But bottom line is, if I'm looking about Gross and I'm looking at a fabrication of the evidence, I'm trying to figure out what it is I'm going to give Gross the business about. The cards,
right?
That may be one. I can't really talk about the investigative reports.
Correct.
He's no longer in the investigation. So the cards are it.
The cards are in, and we can't get him for his testimony.
Oh, how did that evidence cause the deprivation of liberty in relation to the underlying charges of attempted murder and shooting into the inhabited building?
Right, and that's Caldwell. And Caldwell says, a charge is enough, conviction's not necessary. This case was infected with gang theories. The judge said it's a horrible shooting by gang members. The DA said...
Well, but just a minute. When we're talking about attempted murder and shooting into a building, gang evidence has no bearing on that at all.
Had all the bearing. It was the entire...
Yeah, what bearing is it?
It was
that you don't even have to prove they're in gangs. You don't have anything to do with gangs. All you got to prove is they attempted the murder or they shot in the building. They were in gangs, had no part of it.
It was the entire motive for the shooting was a gang.
From looking at the reports, because I have scraped off, as I said, the allegations that would have been WIG related. So we're looking at these reports, and we have the cards.
Correct.
I think for Gross and nothing else. Then we have Maxwell's report just that night of the shooting, the incident report, and then everything gets handed off to Keeling, who's our investigator. Right. Correct. It seems to me that the narrative that drives this theory, and it's certainly presented at the preliminary hearing and at the trial, is that this was a gang-related shooting that they showed up. Is it Glass and Perry? There's Crips and Blood. And that comes from Keeling's report, and definitely gets picked up and presented at all of the hearings. But I think that the genesis, to go back to Judge Smith's question for Gross, is the cards, and there's direct evidence. They're just conflicting. The plaintiffs just say we never said that, and the cards say self-admit. Right, so there's conflicting evidence about whether or not they had admitted to being gang members.
Correct.
All right. So then, yep. Yes.
I'm being preempted by my good colleague, but the honest truth is there was never any Maxwell report at the preliminary hearing, was there?
Wasn't admitted.
It wasn't admitted. However,
Wasn't
it was
admitted,
brought,
was it?
The DA brought it to Jasmine while she was on the stand and impeached her with that report. And that is part of the
bottom
docket.
line is the judge didn't ever see that report, right?
I have no idea, Your Honor.
The judge never saw the report from Keeling, did they? William?
I have no idea, Your Honor.
Well, I looked to try to figure out, because we've got to have some way to get them in, and get them applied. That's why I'm asking you the question.
Right. I do know that the judge did see the probation report, because the court does see the probation report. And what does the probation report say?
Probation report not at the time of the preliminary hearing.
Yes, it was.
Okay.
March 25th.
Counsel, you said in response to my question you were relying on Caldwell. Perhaps you could explain how Caldwell helps you.
Caldwell says that the charge is enough, conviction is not necessary to have a deprivation of liberty. The charge was a gang charge, which presented the jury with evidence that they were gang members. The DA called them gangsters at one point in closing argument. Appellants want to show that there's some sort of a cutoff. There was no cutoff.
Caldwell says that if it's deliberately fabricated evidence and the prosecutor's file, it can rebut any presumption of prosecutorial independence, and that a prosecutor's judgment cannot be said to be independent when she's reviewed fabricated evidence. I think it's that case in conjunction with Lisker that gets us to the notion that the narrative, and we've embraced this quite squarely in Lisker, that when police officers if there are factual narratives that are incorrect in their reports, that gets fed into the prosecutor, then that can form the basis of this type of a claim.
Correct. And there's no independent prosecutorial work in this case.
Well, we don't know that. No one's told us that. I'm with Judge Smith. We're just looking at these reports. That's what we know we had, and we can't see that anybody else was feeding any information into the prosecutor, but we don't really even know that here.
Yeah. All we know is that there was no independent work done by the prosecutor. That would have come in.
Wait a minute. That's why I just said I don't know how. How do we know that there was no independent work done by the prosecutor?
It would have come in at the criminal trial. It never did.
That's quite different. I don't know whether the prosecutor independently interviewed people. We don't know that at all. We don't have anything from the prosecutor.
Yeah.
So what is your theory? Going back to the gang allegation, I absolutely agree that it was the narrative, or in trying to figure out defendant by defendant, how is it? How would there be proximate cause for each of the defendants in this case on the gang allegation, fabrication of evidence?
I think that Gross's FI cards were completely fabricated. They were internally inconsistent. He named different gangs than what his fellow officers came up with.
And to Judge Smith's point, you think causation could be established by?
Yes, because those gang cards were exhibits 2 and 3 in the criminal trial, and they were relied upon by the jury. And they actually went back to the jury box.
What about
With regard to Maxwell, I think his gang designation in the charge line is the entire reason it went to Keeling, a gang detective. And he never once corrected any of his gang designations that Dupree was in this 52 Pueblos, even Pueblo Bishops, even after finding out that Keeling found him in a completely different gang, which was a Crip, not a Blood.
So you said you think that's the entire reason this was referred to Keeling, a gang investigator. Was Keeling asked that question?
Yes.
Where?
In his deposition.
And he said that's how he got it? That's why he had it?
He believed that it went to him because he was a gang detective.
Okay. And then what's your analysis as to Keeling?
With regard to Keeling, he's the one that made up all of these witness statements. The witness statements every witness came to court and said something different. And Sheila and Donisha did also. The only reason why Donisha finally got on the stand and said he was shooting in the air is because Keeling talked to her right before she came on the stand.
We do not have evidence of that. You just made this assertion to us, and we're a court, and you're an officer of the court, and you just made an assertion of fact that I think you've agreed is unsupported.
I believe it's in our separate statement, Your Honor.
What?
I believe it's in our separate statement, Your Honor.
Your separate statement? Forgive me. What?
SUF. We can get you. I'll look for
No,
this.
please.
Okay.
Explain this to me. You just said the only reason, Donisha, that sentence.
That sentence.
Is
That is
supported-
Juan and Dupree's deposition testimony where they testified that they observed Detective Keeling pull Donisha, a 15-year-old girl, out of the courtroom before she took the stand, and he came up with this theory. If you look at Detective Keeling's deposition transcript, he says not once but twice, Donisha told me initially she did not see Juan Rayford shooting. Only when counsel said, think carefully about your question, did he say, oh yes, she said she was shooting once up in the air. He changed that testimony.
You are well over time. Do you have any
Sorry.
additional questions?
We're over time.
We're over
Thank
time.
you very much.
Thank you.
Thank you.
Thank you, counsel.
Your Honor, if I may, I have a couple places in the record to point you to that I think will be useful. The first thing I want to argue, though, is that the Smitty presumption is a presumption that the plaintiffs have to overcome. They have the burden. The arguments that they made to overcome were that 2 witness statements were falsified, Jasmine Thompson and Shadonna Williams. Both of those witnesses testified at the preliminary hearing, and then the prosecutor charged the case. The other allegation that they made was that Detective Gross falsified the statement on the FI cards that they had self-admitted to gang membership. Plaintiffs say, we didn't do it. That's not enough to overcome the Smitty presumption. That's what Newman holds. Just because you disagree or your own testimony that you didn't say what happened during that interview is insufficient to overcome Smitty. And that's why the court should rule in our favor on the Smitty presumption. They define the issues to overcome the presumption. They didn't have the evidence for it.
A narrative. We've just spent several minutes discussing their case regarding fabrication of evidence.
That's correct. So the narrative
I know, that's
doesn't
the point.
overcome
It
the
is not the
presumption.
case
You
that
have
they
to
were
put
relying-
evidence into the record. And the only evidence was the fabrication of those 2 statements, and the witnesses then testified and they denied that they made those statements. The question is, did the prosecutor exercise the prosecutor's independent judgment? And the presumption is that the prosecutor did unless you overcome it. We didn't need to have a prosecutor come in and testify. We didn't need to depose a prosecutor. All we had to show was that their
You have
evidence
to tell
was
us why the
insufficient.
district court was wrong.
Yes.
And why was the district court wrong in thinking that this presumption could be overcome if reasonable jurors could decide that there was fabrication?
Because that's not the question. The question is, was there evidence that could have in some way vitiated the prosecutor's independent judgment? And the only evidence they pointed to were witnesses who testified in exactly. So the key evidence that they said is that these 2 witnesses, the statements in the police reports were false with respect to these 2 witnesses. And those 2 witnesses came in and said, yes, we did not make those statements. And the prosecutor saw that. And as prosecutors do, he said, well, I have 2 other witnesses. I now know that I have issues with respect to these
You've
witnesses.
explained this part of the case, and I don't think anybody's pushing back on this part of the case.
Let me push back on a couple other issues then.
I have to do it very quickly because you're over time.
Thank you. On the forensic evidence, Your Honor, you asked about whether the expert said that there were only 2 shooters. False. That's not what the expert said. The expert said, I could determine that the shooters shot from 2 different directions, but I could not determine how many shooters there were. It's undisputed, and that's 2 ER 81, paragraphs 127 and 128. And the plaintiffs did not dispute those facts. That's what the testimony was. With respect to Stephen Gross.
So the notion that if there were only 2 shooters and one is dead and the other one has come forward with a recantation or an admission, we can't say for certain that the plaintiffs in this case, the defendants in this case, the alleged shooters in this case.
That's correct. Well, and you also have to keep in mind that Denisha Williams and Sheila Lair testified that plaintiff Rayford shot into the air. All right. And the entire directional analysis was based on bullets that were lodged in the house. So it stands to reason that if someone shot in the air, whether or not that person shot from a separate direction, there wouldn't be any evidence of it. And as to Detective Gross, the key argument for Detective Gross is that the testimony he provided was solely with respect to sentencing enhancements that were alleged in the case. The plaintiffs did not dispute that the jury instructions for attempted murder and shooting into an inhabited dwelling
But
do
counsel,
not.
again, you're going to the uncontested point. It would be so helpful if you would respond to what she's arguing, which is that he's the genesis of the gang identification, that Maxwell picked that up, and that's why this went to Keeling, and that the narrative of this being a Crips blood shootout came from the police reports. That's her argument.
I understand.
But you're responding to the uncontested part.
I think we're making a lot of assumptions. First of all, the evidence that it got to a gang detective, I don't think that's in the record. I think she's relying on deposition testimony that wasn't before the district court. Even if it was, what does that prove? It proves nothing. It just proves that the prosecutor in the case saw that these two guys had admitted to being part of a gang, and he decided to charge gang enhancements. That's what it proves, at most. But the gang enhancements themselves were never imposed in this case.
This goes back to you're lumping them together, and we are way over time, but you are lumping them together, and I've asked you to, or let you know how I get to the place where it seems to be pretty clear that there wasn't evidence that Rayford shot towards the dwelling or towards a person at the preliminary hearing. And you haven't responded to that.
Your Honor, if there were a lot of things to respond to, if I may, I can submit a 28-J letter to the court. I can point to the record where the evidence is.
All right.
Okay.
We're going to leave it at that. You both went considerably over time. We'll take this case under advisement and get a ruling out just as soon as we can.
Thank you.
All right.